you were so concerned about this event happening that you manufactured it. You made it happen.
We are the Armed Attorneys. Today we're talking about how your training could be used against you should you find yourself in a defensive scenario. We're talking about what types of trainings are making their way into the courtroom and whether you should change anything based on kind of the trends that we're seeing out in the real world. But before we begin, show your support for the Second Amendment by hitting that like button. And to start things off, we kind of see this, I know you hate this term, but we see this kind of trickle of conduct being brought into court with regard to somebody's training and if they find themselves in a defensive scenario and it being used against them. And,
yes.
What do you see?
Yeah, well, first of all, the term I hate is the Richard term, which he calls training trickle, and that just really upsets me for some reason. But yes, what we are seeing, and this is a really more of a global trend, I think, which is that the standard that is generally applied to law enforcement in defensive shootings, all of their training for defensive shootings is slowly being applied to your average civilian self-defender. That is not fair for a myriad of reasons, but we are seeing it across the country. And so this really, I think, is being relied on heavily by the government when it comes to civilian training in the use of firearms and self-defense. That's our training trickle. I hate myself for saying it, but it really truly is a trend we're seeing across the entire country. Richard, do you want to get into what they expect out of law enforcement specifically and sort of how that scenario goes?
I think that's probably the best place to start is with law enforcement, those who are, certified peace officers across the United States, and where we see it originally started with them because police officers would be involved in these use of force or deadly force scenarios. And we saw this come up over and over and over again if they were charged criminally is, hey, you should have de-escalated. Now, a lot of police officers, and this is standard training in most states, receive a decent amount of de-escalation training. And when we see state legislatures asking for police reform, that's always part of it. Hey, we need more training on de-escalation, to avoid maybe the loss of life. Now, when we have police officers, that might make sense for a police officer, but we now see that kind of being used against civilians.
Yes, absolutely. And in fact, I think we'll talk about this a little later on. I've actually had that come up in several murder cases in the last couple of years. So it really is happening.
The police are the starting point, but we see this show up with all different types of training. The next one that comes to mind for me is military. What have you seen? You've actually had personal experience with this.
Yes, actually, we had a recent client who was a ex-Marine and had to defend himself. And sure enough, on cross-examination, the state really went after his military firearms training to, essentially what they were doing with him specifically was picking apart his fear, the reasonableness of his fear.
Yeah, you weren't scared.
Yeah, like, look, you've had all this training. You knew what you were doing with a firearm. You've been in scenarios. You've been trained for scenarios. Like, you should have known better. You weren't really scared, sort of thing. But, potentially, let's say that we have someone who's a military firearms instructor. I think there are all sorts of different lines of inquiry that the government could go down just regarding, de-escalation and all sorts of any sort of you messed up in this arena because of X, right? Because you overreacted, because you reacted too late, because you're really highly trained and you should have placed the shot someplace that wasn't fatal.
Sure.
I know that sounds ridiculous, but that really is sort of how these things go in the courtroom oftentimes. Any of it and all of it comes up, and military is a great example of when they really start picking apart your training and your experience.
Yep. And the next one that I see come up is having a license or permit to carry a handgun. And so this still, and Emily will tell you, if you find yourself in a defensive scenario, we still recommend getting a license or permit to carry. Juries love it. They love hearing licensed gun owner, or he was licensed to carry, or, whatever the scenario may be, they love hearing that. But, on the, flip side of the coin, we have that argument that, oh, well, you're not a cop. It's almost like used against you. No matter what you do, they're going to use it against you. But that's the argument that I hear with a license or permit to carry. Hey, you're acting like law enforcement and you're not.
If you do not have a license to carry or a license, a handgun license in your state, the government is going to use that against you to try to make you seem irresponsible and like you don't care about the law and you don't want to learn anything. So really, they're going to use whatever they can find against you. But I will say, in fact, a recent case, I actually had the government subpoena my client's handgun license instructor and asked him a whole bunch of questions about his what he taught in his class, and specifically actually what he taught about de-escalation.
Right.
And they actually did this in a private meeting, and then they realized very quickly we don't want to put this guy on the stand because it
didn't help their case.
It didn't help their case at all. But they really wanted to take the training he had in his LTC course and try to use it against him. They just very quickly learned that it was a terrible idea.
Yeah. And the last one that I see come up from time to time is folks who seek out private training. Maybe they go to a defensive pistol course or an advanced defensive pistol course, or maybe they go to one of these kind of cool week-long trainings where, you put a lot of ammunition downrange and train for a bunch of different scenarios. And I have experience with a case in this scenario. They kind of try to paint you like a lunatic, like getting your license wasn't enough. You had to go further and beyond this. They, you were begging for one of these scenarios.
Yeah, now I know who you're talking about, and he kind of was begging for that scenario. But yes, no, but really, I mean, and that was a huge issue for him. I know is that he was very, very self-defense minded. He actually carried multiple firearms on him, and by multiple I mean 4 at all times, and had been to tons and tons and tons of training. And sort of the state's theory was
he's a gun nut. That was their theory.
I mean, in a nutshell, right?
Yeah.
And just you were so concerned about this event happening that you manufactured it. You made it happen, basically.
Right. So, I mean, to recap those 4 scenarios: police, you should have de-escalated; military, you weren't really scared; are folks who maybe have a license or permit to carry that they're not cops and shouldn't act as law enforcement; and then finally are folks who go out and seek additional training and maybe they get painted into a corner or tried to be characterized as maybe trying to manufacture one of these scenarios. Now, that's all to say, and I can hear it in the comments section, and I'll let you respond to this, Emily. A good lawyer should keep all this stuff out of court.
Ooh, it makes me so mad when people comment that. Okay, so yes, I get it. You think, oh my gosh, this thing sounds so ridiculous. Why would any lawyer let that in trial? And I'll tell you something right now. Your lawyer has very little control about what's in and what's out, because all the attorneys get to do is either proffer the evidence or they get to argue that it should not be admissible. But who makes that decision, Richard?
Yeah, it's a judge.
It's the judge. Some judges are very, very good and very, very fair. Some judges are very, very stupid and very unfair. And sometimes the call is up in the air and the judge has to make the decision essentially based upon our standard for what is relevant evidence. And, it's encapsulated in a different rule in every single state. But essentially what we're looking at is the evidence more probative than it is prejudicial? But then we also have just general relevancy, which is it likely to make any fact at issue more or less true, right? Those are the 2 sort of standards we look at as to whether or not something is going to come into trial. So does it make anything we're talking about more or less true? If so, is it more likely to give you further information about how you decide on the case than it is to just harm the defendant? If true, it comes in. As you can see, that is very, very subjective, right? And so what's a judge going to say to any given piece of evidence? I don't know, but I'll tell you, at least this is my experience as a criminal practitioner in state courts. Judges are very, very likely to just let a whole bunch of stuff in, let it all go to the jury and let them decide. I mean, barring things like essentially criminal convictions or conduct, other bad acts. Those they're really careful about keeping out. But things like your funny gun signs, things like, what you posted on social media regarding firearms, regarding maybe an incident that was very similar to the one you engaged in.
Right.
I mean, things that even are a little bit relevant, judges tend to let in to a jury, at least, again, my experience.
Yeah, and the standard that an appellate court looks at is, did the judge abuse their discretion and did it cause, harm to the defendant when looking at these things? And judges are given a ton of discretion. They act as the gatekeepers to information to a jury, and they just have a lot of leeway. So
right, and then even if, and Richard, mentioned this 2 steps, even if they abuse their discretion and the appellate court says, yeah, they really shouldn't have let that piece of evidence in, the appellate court is then going to evaluate for harmless error. Harmless error is the one of the huge bugaboos of the justice system, because if you are convicted in a court of law and there was an error in your case, it was harmful, is my opinion. There should be no such thing as harmless error. But courts find over and over and over and over again that even when judges abuse discretion, it was harmless error. And so letting in a piece of information like this, because it's just one piece of information in a sea of evidence, is almost always going to be harmless error, even if they find it's an abuse of discretion.
And now you might be asking, well, as a practical matter, should I not get training? Should I not get a license? Should I quit my job as a cop or not join the military? Because this is, what if I find myself in this defensive situation? Is it going to be used against me? And I think the practical answer to it is you should still get training.
Yes, 100%. But here is where you change your behavior. Don't talk about it in a way that is public and can be used against you. Because what we have here is a scenario in which the state is very unlikely to know that you are well trained unless you tell them.
Right.
Unless you've posted on social media and their investigators find it, unless you mention it if you give them an interview, unless you mention it in your police interview, they're not going to find that information. The chances that any given prosecutor just does a blast of subpoenas to all of the, handgun training outlets in your vicinity, almost nil. And so great that you have done it. It helps all of us when we're well trained. Good information to give your defense attorney to be disclosed if and when he or she decides it is a good idea. But your change of practice here should be not, I don't want to get my license or I don't want to get trained. It should be quiet about it.
Right. And that's always a good principle after a self-defense incident, invoking your right to remain silent and not speaking to authorities without an attorney present. And the last thing that kind of comes up with this is certificates or maybe memorabilia or things like that. I keep my training certificates in a lockbox, kind of with my other important documents. I don't necessarily display them on the wall, God forbid I have a self-defense incident and I just got all these certificates about how well trained I am.
They're in the evidence pictures.
Yeah. I haven't seen that come up yet, but if I was a defense attorney, I don't know that I'd like that situation very much.
No, sure. And I know people get so mad at us all the time. We're just trying to help you people.
Right.
I know that there are people also saying, well, what about the First Amendment, right? I should be able to talk about what I want. Sure, you can wear a shirt that says, I like to murder people and claim self-defense. You can wear that shirt all day long. The government can't stop you from wearing that shirt. We sure as heck can't stop you from wearing that shirt.
Right.
If you have to defend yourself wearing that shirt, is that going to help your case or hurt your case? It's going to hurt you, right? That's the sort of issue we're talking about. Not, well, I don't have my rights anymore. You got all your rights, man. We're just telling you in a court of law what helps you and what potentially could hurt you. And it's easy to sort of, we're all sitting out here in the free world, not accused of murder, say,
sure,
well, I'm not changing anything. This is how I, handle my... I'm telling you, when you're the guy who's been charged with murder, you want to have done every single thing in your power to only help your case and not give the government that fodder to use against you.
And it comes down to a calculated risk decision. That's what we do with our everyday decisions. Do I decide to put on a seatbelt or not put on a seatbelt? It's all going to depend on, how much risk you're comfortable with accepting. And some of these things, there's very minimal risk in having a shirt that says, Gun Owners of America on it. That's a civil rights organization. And, but on the other flip side, if you had a shirt that said I'm a homicidal maniac and I'm going to claim self-defense, maybe that's a higher risk than, some other shirt. So if you're going to make a decision, it needs to be informed and you need to think about the possible risks and exposure that you're exposing yourself to. But, that's kind of not the end of the story, because we see a lot of inadvertent statements or non-calculated statements getting folks in trouble. And where does this come up?
Yeah, so there are lots of things that you could do or say, really in the wake of your self-defense incident, that can contribute to, let's say your mens rea, right? Your guilty mind, things that the state could try to use against you. I highly recommend, if you're wondering, what should I consider staying away from or be careful about in the wake of a self-defense scenario? Check out this video here. It should help you out. And until next time, we're the Armed Attorneys.